We're joined by Mr. Monday Ubani, Senior Advocate of Nigeria, from our studios in Lagos. Good morning. Thank you for coming on this morning.
Thank you, Chamberlain, for having me. Maokwe, good morning also.
Good morning to you, Mr. Ubani. If I may lead the question in, I'd like to ask you, what exactly does it mean? And I know that we've heard this over and over again. I'm sure a lot of people are curious. What exactly does it mean when the Supreme Court say they reserve judgment in a matter?
Yeah, very simple. If a matter has been copiously hired, I mean, you file your processes, and the court give you a clear date for hearing. And after having heard from you, ordinarily the court will give you a date for judgment. But when it said that a judgment is reserved, you know, there is no definite date, but that issue of date will be communicated later. So when a judgment is reserved, it means that it is adjourned for judgment, but the specific date is actually unknown. It can be today, it can be tomorrow. So they have reserved judgment in order to deliver judgment after you have exhausted, you know, whatever you have filed, you know, in terms of maybe oral amplification or adoption of your written brief. The court will now say we have reserved judgment, meaning we are postponing judgment to a later date, but the date is clearly unknown. It can be today, it can be in an hour's time. The communication will be done by the registrar of the court and say, come, and then, of course, listen to the judgment of the court. So that's what it means in simple terms.
Thank you for explaining that. I think the second question will be why? Why do they reserve judgment? Because I'm sure that you've heard all manner of whisperings behind the scenes as to why this happens. Can you tell us why this happens within the jurisdiction of the courts?
Of course, after you have heard the parties, I was in court last Tuesday. If the counsels have filed their brief, I'm sure that Tuesday they would have adopted those briefs that day, pending judgment. But unfortunately, the briefs were not filed. So the court gave yesterday as the date they will now listen to all parties. Gave them a deadline Monday for them to file all their processes, which is actually what happened. They finished filing their processes, and then yesterday was for argument. The court need to study what they have actually written and then said in oral amplification before writing judgment. So they can't just immediately enter into it. It is a constitutional issue, as Chamberlain has actually pointed out. Very grave constitutional issue that requires proper appraisal, looking at what the issues are and then making a pronouncement. Because again, the issue of jurisprudence is key. It is already an established fact that on issue of internal matters of the political parties, the court, as far back as in the 80s, have laid it down that, look, the courts do not interfere in matters that are considered internal. But over time, exceptions, you know, grew. That if what you are you know, coming to court to argue has to do with breach either of your internal rules or your guidelines or your constitution or even the Constitution of Federal Republic of Nigeria or the Electoral Act, the court will actually listen to that person who has come to court for issue of grievance, you know, to be redressed. So over time, they now make it a statutory provision. Even the current Electoral Act also has it in Section 83, that you do not interfere in internal affairs of the political parties, except, and those note grounds were actually properly specified. The Act even went further to now impose punishment on lawyers who come to court over matters that are clearly regarded as internal affairs of the political parties. I think that the lawyer will be asked to pay 10 million, not even the litigant. A lawyer who accepts a brief that has to do with internal affairs of a political party and who comes to court to ventilate a matter that is purely an internal affair of the political party will be asked to pay fine now. And lawyers are arguing whether that is not denial of access. You know, but it's a different ballgame entirely. What we're saying is that issue that will be determined is very grave constitutional issues. So they need to take time, look at what parties have filed, and then give the judgment that will satisfy the aspiration and yearning of all the parties that are before the court.
So on that particular point, the appellants clearly relying on that long-standing principle, courts not interfering in internal affairs of political parties. Shouldn't there be a place where a line should be drawn? And where should it be?
That's a very intelligent question. As I said earlier, it is now, there is an enactment that says any matter that has to do with issue of governance structure, issue of nomination, issue of discipline, and all the rest thing that has to do with internal affairs of the political party, they are non-justiciable. It is now in the Electoral Act. Now, the same act now went further to say, look, if the person that is actually coming to court to ventilate his grievance is now saying that the political party itself has actually breached their own constitution, or the constitution of the Federal Republic of Nigeria, or their electoral guideline, or even the Electoral Act, then where there is a wrong, there is a remedy. The court will still have to come in order to look at the grievance of that party that has come before it, in order to determine whether he is right in what he has said or what he has not said. Because it's not a blanket thing that if it's an internal affairs matter of the political party, then the court will run away. The court will look at the writ of summons, or the processes in order to discover what the party is complaining about. If it's saying that there are wrongs that has been committed in breach of clear enactment, statutory enactment, then the court will interfere and look at it, holistically and determine whether such grievance should be redressed. So we need to understand that is not issue that if you say it's an internal affairs of the political party, then the court will run away. The court will look at what has been brought to really know whether it is purely an internal matter that does not require interference of the court. And they have specified them. If it has to do with nomination, issue of who is the leadership issue of governance of the political party, issue of discipline, you don't go to court to go and debate those issues. These are clearly internal affairs of the political party. It shouldn't come and disturb the court. It's non-justiciable. But if what you are saying is that in that process of nomination, the political party has even breached their own rules, their own law, the Constitution of the Federal Republic of Nigeria that says this man is not qualified to run, then the court will have to look at it and take a decision one way or the other. These are clearly, what we need to explain to Nigerians, concerning this issue of internal affairs. Of course, that was established in, I think it was either Ono and Okafor, by the Supreme Court, and over time, even Turaki, and all that, and Dahatu, and several other authorities have actually aligned themselves to that particular decision. The internal affairs of the political party is non-justiciable, except, and I have already specified those exceptions, if there is a breach, then the court will have to interfere.
In the case of the ADC, which appears a little tricky, because, there are several narratives why some people thought, in the first place, when the court even said, just come and explain to us why we shouldn't take certain steps, and then there was that appeal. So questions concerning why did they even need to appeal? If they didn't appeal at that point, where would the matter have been now? Because this is not even a substantive matter. So even if they determine this matter, what's going to happen to the main matter of the ADC itself? So could you explain that build-up, how they even got to the point where the court now spoke about status quo ante bellum?
Yeah, Chamberlain, again, this is a very brilliant question. And people need to know actually what happened in ADC. I was in Supreme Court last Tuesday when this matter also was being debated until it was adjourned to yesterday. What happened in ADC matter is that the leadership issue came up, with Bala Nafina Bala, who said he was supposed to be the chairman or acting chairman of the party in the absence of the substantive chair, who resigned. And that the leadership that eventually emerged was not in accordance with the constitution of the party. So he went to Federal High Court in Abuja, I think before Justice Mwite. Mwite now asked all the parties, that were respondent in the case to come and show cause why he will not grant the restraining order. In my own thinking, I thought that the ADC should have gone to tell the court, this is a matter that is non-justiciable. This is a matter of abrogating and reprobating. This is a man who has allegedly resigned, so what is he coming to court to do? Or tell the court at least the court lacks jurisdiction. But they chose going on appeal, and I don't know what they were appealing against. But so when they got to Court of Appeal considered that appeal as being incompetent, premature. The matter is before the lower court, and they're asking you to show cause, and you're coming to Court of Appeal. So go back to the Federal High Court, and respond to whatever query that has. They have not taken a decision against you. They're asking you come and show cause why we should not take this decision. And the only problem in that case is that if the court now dismisses that appeal based upon the fact that it was incompetent, this issue of making an order of maintaining status quo antebellum, which has actually brought the confusion, in the entire process. I don't know whether it was absolutely necessary, but this is what the Supreme Court now we eventually decide in this matter. They made that order. So ADC has further now appealed on that interlocutory decision to Supreme Court. And it is a matter that is a bit dicey, but I know there may be steps that the Supreme Court may take in order to resolve all this issue. One of which is under the Section 22 of the Supreme Court Act. The Supreme Court can assume jurisdiction as if that this case is originally filed before the Supreme Court and determine this matter in its entirety without referring the matter back to the Federal High Court. It can't do that because the law allows that global power to the Supreme Court. In a matter like this, that there is a sense of urgency, is in the interest of the public, that this matter be hastily disposed of in order to actually put the polity, instability.
If I could just follow up on that,
but let me
before
finish,
you move on to your next point.
Okay.
It's just on this same clarification. I hope you don't lose your train of thought on this one.
Okay.
If, according to the rules of the court, they can assume original jurisdiction on this kind of matter, under what circumstances? I mean, you hear you lawyers always say, look, the court is not Father Christmas. They don't give you what you don't ask. If the appellants don't ask, can the Supreme Court, on its own, assume that jurisdiction, even though perhaps they will say, considering the time frame that we've got on these electoral matters?
They may have asked. I heard a bit of it of saying, the issue of jurisdiction can be raised at any time. You can raise it even for the first time at the Supreme Court. So if they are raising the issue of jurisdiction now, and again, as I said earlier, those processes must be in the file. And it must show that there is not going to be any necessity of a witness, giving evidence. Because if it's a hostile issue that requires evidence, of course, the Supreme Court cannot assume jurisdiction over such matter because it's a final court. It does not take witnesses. So it is important that the issue is one that can be resolved without a witness coming to come and give evidence. So that is where. So there are also conditions for the Supreme Court assuming that global, jurisdiction. We talk about the power to now decide the matter as if it was filed for the first time before the Supreme Court. So those conditions must be fulfilled before the Supreme Court can do that. But if issue of jurisdiction is raised by ADC, maybe the Supreme Court can say, yes, let's look at the issue of, did the court below have jurisdiction in the first place? They can determine that. These are options. I'm not saying that the Supreme Court may take that procedure, but it is in the interest of the public, even Nigeria, and even for the survival of our democracy, for Supreme Court now being a court of policy to look at this particular matter, looking at the timeline concerning the electoral process entirely, to say let's have this matter finally disposed of at the Supreme Court level without referring this matter back to Federal High Court, because it's a process. Going to Federal High Court again, look at the timeline of the timetable for the nomination of candidates and all that. So it is something that the Supreme Court can, provided the condition is met. That is a matter that they have all the papers, everything that has been filed, and then it can be disposed of without any witness, coming into the matter, because Supreme Court is not a court that, hear witnesses. They don't listen to witnesses and all that. So if that condition is fulfilled, they can dispose of this matter finally, because the matter that is before the Supreme Court in ADC is interlocutory. The substance of the matter is still pending at Justice Mwite's court, who say, come and explain why. And then they are saying, look, it is an internal matter, but you didn't go to court to tell that court that clearly is an internal matter. You didn't file any paper to that effect. Then you went to Court of Appeal. Court of Appeal said, go back to court of, lower court, and decide, let that decision be taken. Then you are now in Supreme Court. So I think the Supreme Court, you could see the sense of urgency, you could see the sense to do justice, you could see the sense to stabilize the polity by assuming jurisdiction over this matter and even giving them a date, for the matter to be heard in an expeditious manner, which is what the Supreme Court has done. Kudos to Supreme Court. But I also probably beg that they can probably go further to dispense this matter completely at the Supreme Court level if all the conditions are met. If the conditions are met, they can finally decide this matter and then let there be some level of rest, because everyone's heart is clearly in their mouth, concerning this matter.
I think we can go back to the issue of confidence, because that's another issue that, will clearly come to the fore in this matter. We've seen over the years political matters are things that a lot of people have a lot of interest in. People are wondering which way for our democracy. And certainly you are aware that, whatever it is, whatever decision their lordships reach on this matter will have grave implications for the 2027 elections and, well, maybe not just the 2027 elections, but our democracy at large. So how confident are you that our Supreme Court, and in short, the entire judiciary, is still capable of holding the confidence of the Nigerian people, especially as we go into the 2027 elections? Again,
this is a brilliant question. I think we need to sustain our confidence on our judiciary. It remains the last hope of the common man. If you see the interest the Supreme Court has shown in this matter, giving them, say, look, if you have filed your processes that last week, we are ready to have this matter, disposed of, So that shows sense of urgency. They also read newspapers. They are part of the polity. They are citizens of the Federal Republic of Nigeria, and I'm sure they want a situation where our democracy will not be imperiled. They are interested in the stability of the nation. And so I have this absolute confidence, one, as a lawyer, secondly, as a citizen, and then as a senior member of the bar. I don't have any doubt that the Supreme Court will do justice to this particular matter and ensure that we stabilize the polity and that there is no confusion anywhere, even as we head towards 2027. It's a critical decision, that will determine the health of our democracy. It's very important, and I think they take it serious too, because I personally went to court to see, the feeling, the urgency, the way the matter is being handled by the Supreme Court, and I must tell you that I was satisfied with the posture, that I saw. And I know that this matter will be determined in no distant time so that we can have peace and continue with the electoral process of 2027. I have no doubt in terms of confidence that they will do justice to this matter and determine the matter in such a manner that Nigerians will be very satisfied.
Well, we look forward to that. I think we also look forward, we are unsure what the decisions we reach, and we're hoping that the parties that have taken the matter to court, yes, whether this is in their favor or isn't, I'm hoping that they will be able to take it in good faith. Because oftentimes what we see is that when the Supreme Court, or any court at all, rules in their favor, then they say, oh, the court is the last hope of the common man, and indeed they've come to the rescue of the common man. But when it doesn't work in their favor, they are also the first to cast aspersions,
yeah, it's very important,
of course, yes, chips away at the credibility of our courts.
Yes, it's important we say this. It is what you bring before the court that the court will decide on. The court is not a Father Christmas. The court does not operate on sentiment. It's very important, because most times we see sentiment flying about, especially when issues that are politically charged cases come before the court. Whatever you have filed is what the court will look at and decide on that particular matter. It's very important we point out that. And what the court is about to decide concerning these two cases is issue of internal affairs of the political party. Does it exist? If it does exist, are there exceptions? And these cases, do they meet those exceptions? It's important we narrow these issues so that people will not, expect the court now to play a role that is beyond the jurisdiction of the court. The court will decide based upon what you have filed. Is there issue at all? Is this matter internal affairs of the political party? If it is internal affairs of the political party that does not require interference of the court, was the court below right to have interfered? If the court below was right, the court also will say it. So I don't see any complication in this matter. It's very straightforward. And I know that the Supreme Court will be in a position to do justice to this matter. So, but if you didn't file anything that the court will decide upon, it will not go outside what you have filed in order to decide a different thing entirely for you. It's very important that these things are pointed out.
Well, without asking you to predict the outcome of these cases,
yes,
what would you say are the key legal principles the Supreme Court of Nigeria will prioritize in resolving these kind of matters?
For PDP case, it's very straightforward because, there was hearing, from beginning, so the issues are narrowed. There was a convention, And somebody went to court and said that convention shouldn't hold because the congresses that should produce the delegates to the convention were not properly conducted. So that is his allegation, So the lower court already made an order, the Court of Appeal approved, and now we're before the Supreme Court. So was the convention properly held? The congresses that produced an order, so the court will determine, and then their own argument is, look, this matter is purely an internal affairs of the political party. So does this particular case qualify? So it's narrowed down, because from beginning, the issues, started from the lowest court to Court of Appeal, now to Supreme Court. But in the case of ADC, it's not as easy as that. Because in the case of ADC, the lowest court said, come and tell me why I should not restrain you from acting or for being the leader of that political party. But they chose to come to Court of Appeal. And the Court of Appeal said, no, this is premature, he's incompetent, go back to the lower court. So they now made an order, that strange order that is actually now the crux of the matter before the Supreme Court. Status quo ante bellum. These are Latin maxims that have created so much confusion. In whose favor? At what point is the status quo to be maintained? So these are issues. This is an ambiguous issue that the Supreme Court will give clarity to in that decision. But again, whether the Supreme Court now will now assume jurisdiction and say, okay, let's do this particular matter and dispose it as if it is filed before us, in the light of what they are saying, that it is an internal affairs of the political party that shouldn't have, involved the court at all. The court shouldn't even have listened to it. Maybe we have not yet come to the level where we begin to shift, look at cases when it is being filed and say, oh, this is this is an internal affairs, and say, don't file it. But the moment it's filed, and the court now is assigned to a judge, the judge will first of all determine whether he has jurisdiction. It is for you to tell the court that he has no jurisdiction. The court cannot, unless so much to most times, say, okay, I don't have jurisdiction. But you have to come and tell the court most times that it does not have jurisdiction. This matter is non-justiciable, before it can now make a decision. But in that case, that is not what happened. They went to Court of Appeal. Court of Appeal made a pronouncement that they felt was wrong. They have now proceeded on interlocutory appeal to Supreme Court. So whether the Supreme Court will assume jurisdiction now and handle this matter holistically and deal with it, it's a different ball game. It should be a prayer point for ADC. ADC should pray that the Supreme Court will come to that level of taking over. So, okay, let's determine this matter, whether it's an internal matter of the political party that shouldn't have involved the court and all that. Just like Justice Lifu, I think it's either Justice Lifu or one other judge somewhere in Nasarawa has now said that it's an internal affair that he struck out the matter completely and all that. There was a particular federal high court that did that recently. So whether the Supreme Court will do that now, assume jurisdiction and determine that matter once and for all, let ADC now be in a prayer mood in order to see whether that can happen.
Prior warriors, that's your call there. So as we wind down on this one, we know the clock is ticking because the timetable is already out. Parties have to conduct their primaries. Some of them are fixed 15th, 16th, 17th of next month and things like that. So assuming perhaps maybe the court doesn't decide on these matters within the time frame as required by the electoral, by INEC, are there possible circumstances wherein if it's decided beyond the requisite time, it becomes academic? Or if it's decided beyond that time, will it be the nature of the decision that can ask or make INEC alter its timetable?
I think the Electoral Act itself has provided a timeline for all this. And whatever INEC is fixing is based upon what the Act itself has provided. They have extended the timeline. They have looked at the Act and said, okay, this can be accommodated. So I don't know whether there is more accommodation, based upon what INEC has done. But I tell you this, the justices of the Supreme Court, judges in the country, they all listen to newspapers, they listen to television, they also know what is going on in the country. And they know the urgency that is attached to these cases, and they want to dispose of it, So that urgency, sense of urgency is there. And I don't think they would want to take a decision that would become pure academic. They want to, these are life issues, and they want to dispose of it in a manner that parties will know their rights and liabilities, before the convention, before the nomination closes. So I'm not in the one of those that will be thinking that the Supreme Court will not be mindful of this timeline and decide this matter in a manner that is expeditious.
All right, Mr. Monday Ubani, Senior Advocate of Nigeria, thank you for your time this morning.
Thank you for having me. Good morning.